Constitutional, Legal Affairs and Justice. I'm Tanya August Phillips, MLC. I chair this committee. With me are Laurie Hooper, MHK, and Stu Peters, MHK. Before we begin, can you make sure that your mobile phones are off and on silent? And I will add laptops to that as well. Today we welcome the Minister for Justice and Home Affairs, the Honourable Jane Paul Wilson, MHK, and also the Chief Officer for the Department, Dan Davies. For the benefit of Hansard and anyone listening, could you please introduce yourself, including your title and how long you've been in the post?
Yes, good afternoon. Jane Poole Wilson, MHK, Minister for Justice and Home Affairs, and I've been in post for 3.5 years, I think.
I'm Dan Davis, Chief Officer, Department of Home Affairs, and I have been in post since August 2018.
Thank you very much. We'll start with the legislative programme. So in the Island Plan, there have been 6 pieces of legislation in development and planned for 25-26. Are these on track to come into the branches and out of the branches before the 2026 election?
Well, I think, unfortunately, I don't have a crystal ball, and it's incredibly difficult for me to say that everything that we hope will progress fully through the branches before the end of this administration. It's incredibly difficult for me to say that absolutely will happen. But we have had a good look at our work schedule and the items that remain in the Island Plan as items that we would like to progress. We are currently aiming that, yes, we want to get them through the branches. But, you know, we're aware, we have ongoing resourcing challenges, so there are reasons why matters can, unfortunately, slow down, but we're intending to try and keep progressing as best we can.
And you're confident that the Attorney General's Chambers is able to resource the drafting instructions that might be coming through to them, though?
I can't really speak for the Attorney General's Chambers. I mean, I know, obviously, there will be quite a lot of legislation coming through from across government, and certainly we engage very well with them. Our priority at the moment is Justice Reform Amendment Bill, so that's our clear priority. We also have the proceeds of crime legislation, for which the consultation recently finished, so we're working our way through the feedback, and dependent on what comes out of that is whether we will have any further drafting instructions to go back to them. And similarly, the extradition bill, the consultation for that closes today, so to some extent you're in the hands of what comes out of consultation. Are further drafting instructions needed, and what is the capacity of the drafters at the time that you're feeding back into the system, but we will continue to liaise as closely as we can to make sure we progress.
And I think we've had some excellent support from Chambers in terms of secondary legislation.
Yes,
we've done 2 quite complex, although simple on the surface, pieces of legislation. So we've used the provisions in the Sexual Offences and Obscene Publications Act to apply UK sentencing guidelines. So we have an order going to Tynwald in April, which will allow the introduction finally of the Child Abuse Image Database. So that means that members of the constabulary will no longer have to manually sift through images to categorise them. So, but that on the surface looks like a really simple piece of legislation, but actually it was really complex because of the interplay between the UK sentencing guidelines and the way that we describe indecent images or indecent photographs of children, how they're categorised. So that actually took far more time than we thought, and the ANPR legislation took far more time. We also did some amendments to the liquor licensing and public entertainment regulations, which also took more time. So what we're finding at the moment actually is that the complexity of dealing with the secondary legislation is probably taking more time, and that's right, isn't it? Because the detail, particularly in contemporary legislation and contemporary drafting, the detail is in the regulations, but
meat on the bones.
The meat on the bones, but it has taken us more time. So I think there has been within the Attorney General's Chambers a couple of periods of sickness, I think, which have contributed to the development of certain bills which have been delayed, but I think we have made good progress. So the National Infrastructure Security Bill is now ready for drafting instructions, and colleagues are liaising with Chambers on that. As the Minister said, we've had 3 bills go out to consultation for POCA. The extradition bill, I think there's a contempt of court bill which is just about ready, and I think also with legislation like the Sexual Offences and Obscene Publications Act, that's taking some time to bed in. It's been hugely effective. The impact on the ground has been excellent. The constabulary have really made an effort to step things up, but but supporting colleagues in the operational implementation of that also takes time.
I'd imagine that supporting the public through that process has also taken a lot of time.
Yeah, I think so. And I think there's a huge amount of public demand for changes to the sexual offences legislation, and people are certainly seeing more offences and more diverse offences going to court, which I think is the aim. And it's really good to see the impact on the ground. So there was a recent conviction of somebody using pseudo photographs, for example, pseudo images generated of children, which is something that we wouldn't have been able to prosecute under the previous legislation. So I think that's one of the great things about the Isle of Man, in the gap between the formulation of policy, the implementation of legislation, and the impact it has on the ground is really easy to see on a day-to-day basis.
I think, small community as well, and the three pillars of government sort of working neatly together in making sure that those discrete conversations happen to ensure that anything gets picked up, I would imagine.
Yeah, and I think the sexual offences legislation is a good example, actually, of, yes, it took a while to prepare to switch that act on just over a year ago, but actually the degree of training and preparation was the right thing to do. I think the other thing we've decided as a department then is to take stock of it about 18 months, the first 18 months of its operation, just to see how it is progressing and what further we may need to do in terms of continuing to support its effective use to support victims, but also in terms of, other areas around improving the criminal justice system, and, what are the other actions you can take as you monitor how a piece of legislation is used in practice.
Kind of a bit of post-legislative scrutiny taking place a little bit earlier, actually, than would normally be expected in that 3 to 5 year timeline since something would be implemented.
But I think I would suggest that you're right. You probably do want to allow a decent run-in of legislation to really test whether it's delivering what you want. But I think what we're seeing is the use of this legislation has happened, from the get-go, and I think it's from an operational perspective and looking at how the whole justice system is working with this legislation, it is worth a stock take round about the 18-month period is what we thought we would go for.
And I think one of the lessons we've learned from this is the downstream impact. If you think about the prison, there are more people in prison for domestic abuse offences. There are more people in prison for sexual offences, and I don't think I think we underestimated the impact that would have on the criminal justice system. And for future, I think as a learning, we probably need to do more in the way of that assessment of the broader impact on the criminal justice system as a whole. And the police service are, they've got a really small people in their protecting vulnerable people team, but also the protecting vulnerable people investigation team, and just dealing with the huge amount of offences that are going through that team, that is putting a real strain on that team.
Because back when the sexual offences in the last administration, say for example, when a lot of this was being worked up, you say that we're kind of like reflecting now on something that perhaps should have been picked up back then. Do you think we have a full understanding of the size of the problem now, or do you think that because the legislation is in, it's therefore, more people know about it and therefore they're more likely to report?
I think I don't think you could at this point say we have a full understanding. One of the things that has struck me is what is now being reported and investigated, I don't think has suddenly started happening. Consequential on putting that legislation, both domestic abuse and sexual offences, in place. I think what we are seeing is that these were issues that were very much there, but they may not have been reported, and they certainly probably couldn't have been investigated and prosecuted as particular offences until we introduced the relevant legislation. But I do think the combination of having the legislation, but also a degree of, as you've said, public awareness, public confidence that matters are being dealt with, that they will be progressed, that where they meet the threshold test they can go forward to prosecution, the reporting around successful prosecutions. I think all of those things actually encourage people to come forward. And the other thing that we are very alive to is that the dedicated sexual assault referral centre being able to be opened and come on stream may again encourage more people to come forward, which will be a really positive thing. But in terms of, do we know the full extent of likely offending and potential scale of investigation and prosecution, I'm not sure it would be wise to say that we really do know that at this point.
And certainly with the new sexual offences legislation, there are novel offences introduced which are for the digital age. So things like, the generation of indecent images of children through the use of AI, or upskirting, image-based abuse, revenge porn, all those kind of things, which are just evolving now. And if you think back, there was a JSNA done, I think, in about 2018, November 2019. It was a joint needs assessment on domestic and sexual abuse, and I think at the time there was an estimate of kind of offending. I think it was saying that there were probably about 690 people who were likely affected by domestic abuse just in the Isle of Man, but that level was probably significantly underreported. And so I think you're right. It's a combination of things. It's awareness. It's people seeing successful prosecutions. I think in the press really helps, and I think the confidence of the constabulary and the prosecutions to get to grips with the new offences, and so the offending behaviour, and to get better at dealing with it and getting successful prosecutions. It's all takes time. So I think you're right. At the end of 3 to 5 years, that would be a good time to do a post implementation review and an assessment analysis of the success of the legislation. But I think our kind of 18-month in reflection on sexual offences legislation is really helpful to see if there are any interim tweaks need to be made, or anything needs amending.
Okay. I think we'll come on to a little bit more about sex offences a little bit later on, certainly justice reform, but extradition, just so that we understand where the policy actually sits. Say policy, does it sit with the Attorney General's chambers in working it up, or does it sit with DHA in terms of the policy and then them working it up? How's that kind of working?
It actually sits with Cabinet Office. It probably straddles 3 departments. So it sits with Cabinet Office for the compliance with international standards, the financial crime element of it. I think it sits with the Attorney General because on a day-to-day basis they generally deal with international requests for extradition, and then the Department of Home Affairs holds the can more broadly for, that's the wrong word, isn't it? It holds the brief more broadly for criminal justice matters.
It describes it well, don't it?
Yeah. So that's where it sits.
And contempt of court, that's due out this administration, is it?
Yes, as we understand it, there's a pretty well drafted bill. What we're trying to do is there are quite a lot of pieces of legislation that are pretty advanced. Either we've got a good working draft of a bill, but as I said before, we are really trying to be quite focused on prioritising what we need to deliver, in priority order. And then as there are gaps in each part of the system's working schedule, to progress the next piece of legislation. So I expect, as I say, POCA 3 bills, extradition bill. I think we will see the contempt of court bill coming through because, as I understand it, that's a pretty well drafted bill now. Justice reform, we're keen to get that out for consultation. And then, as Dan has alluded to, the National Infrastructure Security Bill drafting instructions, I believe, have just gone in. And then we've obviously got the 2 fire bills that we have done a consultation on the principles. So the output from that is being collated with a view then to developing those drafting instructions. We're also keen to make some progress with our police amendments bill, but that is lower down the list because we have to prioritise the legislation that I've already alluded to. And I think the other area is we're quite keen to make progress on firearms, and so there has been consultation with the consultative committee, and based on their views around how that legislation might come forward. Again, when we've worked through the top list of priority legislation, then we can start to move that again. I think, as the Chief Officer has also said, though, alongside this, we are moving tranches of secondary legislation, which is either to deal with other priority areas of strategy and policy, or sometimes in the case of the CAID, that's a really, really important thing, I think, not only to be more efficient and effective in the way that we investigate sexual imagery offending, but actually it makes a massive difference to the staff in the digital evidence unit that can be automated rather than having to be looked at by staff.
And we've also got the regulation of surveillance. Did you say that?
I didn't say that, but we have, yes.
Regulation of surveillance, etc. Amendment bill, which will introduce powers to allow the police to compel people to release biometric and fingerprint information to phones, but also introduce the powers on the face of the bill to use facial recognition in certain circumstances.
Thank you. There are 4 pieces of legislation that were removed. Can you just, for the sake of those that are listening, just give an overview of why?
Yes, so, I mean, and actually, that language removed, I mean, that is really an acknowledgement that those would not be developed sufficiently to progress through the branches this administration. So I think it's important to be clear that it doesn't mean that any work that has already been undertaken on those pieces of legislation is lost. It's a recognition about priority and resource and timing. But one of them, actually, the Financial Intelligence Unit Amendment Bill, that's simply because there was a recognition we didn't actually need primary legislation. So instead what you will see on the order paper for April Tinwald is the order, Financial Intelligence Unit order, which extends the definition of financial crime. The bill to replace the Interception of Communications Act and Regulation of Surveillance, etc. Act. We did undertake some high-level policy work on that a couple of years ago because the Information Commissioner, we've had some reports to say we do need to modernise and update those areas of legislation. So we have had an initial piece of policy work, and as I said before, that's very helpful and it can be picked up again. But in the immediate list of priority legislation, it was not deemed to be as critical as some of the other pieces of legislation. And the sentencing bill and the hate crime bill, again, they haven't had as much work really progressed on them. A little bit of work has begun. It won't be lost though, but again, it's a prioritisation exercise that we just recognise we haven't got the resource or the capacity to progress all of the work on those pieces of legislation.
And just a quick one before we move on. The borders legislation or the security legislation, could you give me a bit of a background on that and where we're up to with it at this point in time, what we're expecting to see in that piece of legislation?
So this is the Information Sharing Security Bill. So this speaks to the Securing Our Island strategy and is really to support more effective, regular ease of information sharing between the agencies, or the law enforcement agencies that are involved in certainly policing and enforcement work around our ports of entry. We do have a pretty well developed draft bill from, I think, a few years ago. Again, from a resourcing perspective, Home Affairs was probably going to struggle to progress that piece of legislation alone. But actually, we have engaged with Treasury because it covers immigration and customs. And so, in fact, we have immediately one of our pieces of work coming up is to sit down again and talk about how that piece of legislation is being prioritised from a Treasury perspective, because they we hope will be able to progress that or help us progress that more rapidly than we would if we had to do it ourselves.
And that's one that's gone out to consultation already, is it?
It has previously been to consultation.
Previously.
Put out by the Cabinet Office,
Yes.
but it needs revisiting.
Right, okay.
Just a quick one. You mentioned the sentencing bill has dropped off your radar. Do you see any potential issues with that? I know we've seen reports of the prison itself getting fuller. Is that an indication that our sentencing regime probably does need to be updated, because we do seem to default to incarcerating people as being the solution, and partly is that because we don't have other sentencing options that may be available to judges in other jurisdictions?
So I think it's a really interesting question. We were looking at the stats for the prison, and I think our current numbers, I think you said at least 60 of the
66 people are on long-term sentences.
Are on long-term sentences at the moment. So I think it's a good point, and I think as part of the criminal justice strategy work that we're engaged on, what should our vision for our criminal justice system be in terms of an efficient and effective criminal justice system that delivers meaningful justice for victims, but also tackles offending behaviour and tries to reduce reoffending and helps to promote a safe society. I think the question about actually, have we got sufficient tools and are we using them as well as we can to get those outcomes is a valid question. Now, I don't necessarily think that the sentencing bill per se is the be all and end all of that, if that makes sense. One of the things that we are going to try and fold in, I think, to the criminal justice strategy review is other innovative ways of proceeding, and one example of that would be should we be piloting problem-solving courts? So if we look at the proportion of the population in the prison who might have an addiction, is there any benefit in us trialling a proposal like that, whereby you may have been convicted of a particular offence, but before you move to sentencing, there's an opportunity to do some intervention work to see if we can change the offending behaviour in another way. So I think it's a valid question. I do think we have to ask ourselves, are we missing any tools? And if we are, how can we fix that? But I'm not sure it will slow down or stop us looking at what else we can and should be doing as part of the criminal justice strategy to make sure we're dealing properly in the best way with different types of offending.
But surely those sorts of post-conviction, pre-sentencing interventions would need a legislative basis that currently doesn't exist.
Well, it's very interesting. We had the benefit of going to the Caroline Weatherall Memorial Lecture the other week and listening to the experience in Northern Ireland. And we are going to do some more exploring around this, but I don't necessarily think it is a barrier per se. So, I mean, I can't stand here and say there's nothing we would need to change legislatively, ultimately, to bring in any other further tools that we may want to use. But, I don't, if we can proceed with ideas like that without needing legislative change, then, we would try and do that as part of the criminal justice strategy work.
And you mentioned there the criminal justice strategy. Your most recent department plan, 24-25, says that review was going to be completed by December of last year. Obviously, we're now in April. Where's that up to? So
I think in the Island plan update, we've recognised that work again. We've had quite a lot going on, as you will be aware from the legislative work that I've outlined, and we've also had some unavoidable absence in the team, particularly in the last quarter of last year. So that work slowed down a little bit, but the review, I think, is more or less there, and the refresh of that work, drafts are coming forward to go through the Criminal Justice Board. We also did commit in the policing consultation we did last year to actually some level of public consultation on a proposed refresh of the strategy. So we said we would try and target July Tynwald for that refreshed strategy. Because we've said we'll do some public consultation, I don't think that's realistic that we will get it to July Tynwald, but I think our hope is that we'll be able to get it out for consultation over the summer and then try and get it to Tynwald by the autumn.
You mentioned there that some of the delays that have been that you've suffered here are through things like unavoidable absence, sickness, or whatever it may be. Does that indicate a lack of resilience within the department structure to deal with these sort of issues, which we all know will come up every now and again?
Yeah, I think that's fair. So since kind of probably 2009-10, the department reduced the headcount in the centre by about half to focus on responding to frontline need. I think we have taken steps in the last 12 to 18 months to try and build a bit more resilience in the centre, but it's a difficult balance. We're all under huge financial pressure. We have created another policy and admin role. We've got a number of part-time roles, and that's given us enough capacity to then have another policy and legislation officer. But I think I've said before at this committee, we actually have probably the most significant and far-reaching legislation probably of any department, really, in terms of the impact on people's rights and freedoms and the coercive powers that people in the constabulary and the prison have. And we are significantly under-resourced. We are trying to address that, and we have to prioritise. So there's a huge list of legislation which we'd like to push forward, but also the policy work behind that is really important. As you said, things like sentencing and sentencing guidelines, and understanding the impact, for example, of drugs on our community, and we have made a start on that through the Liverpool John Moores report and the policy principles that support that. But it is a daily balancing act in terms of how we allocate resource, either to operational issues that require support. So, for example, the prison is currently at 160 people at unlock today. We need to consider how best to respond to that and what that capacity looks like. But we've also had a huge amount of change in the way that we hold the different divisions within the department to account. The HMIC FRS report said that we didn't do enough to hold the Chief Constable to account properly. We've changed that. The reporting structure on a quarterly basis and the amount of information the Chief Constable has to report on is significant now. But that takes resource from within the department to do that. The prison is held to far greater account in the way that they operate, and the Fire and Rescue Service too. But all of that is internal resource that we have to allocate to that to make sure that we're holding the service heads to account for the delivery of services and the use of their powers in a small island.
Can I just ask, could you just repeat how many people are in the prison at the moment?
160 people at unlock.
Is that sustainable?
In the short term, it is. The prison staff are doing an amazing job. So you know that the prison capacity is normally 143 with the additional 24 spaces we have. Then that has given us the additional capacity. I do want to say that the men and women in the prison are doing a really remarkable job in incredibly difficult circumstances. Every single aspect of the prison is being tested, but I also think that the cooperation from prisoners is really important, and the people in prison, it's not an easy position to be in when the prison's so full. So we are looking at a range of options. We're looking at a range of things like tagging disposals rather than custodial disposals. We're looking at additional wing for the prison in terms of a build for the prison potentially is an option. If you look at since probably April 23, the numbers have continued to increase, and we have 66 people, as the Minister said, on long-term sentences. And as you know, a long-term sentence under the Custody Act is 4 years or more. So there are 66 people in prison on a sentence of 4 years or more. So they will be there. You'll have a cohort of 66 people who will be there for the foreseeable future. That issue isn't going to go away. So we need to ensure that we're using the appropriate disposal, back to Mr. Hooper's point, for the appropriate punishment.
I think I would support what the Chief Officer's just said about the incredible work that the staff at the prison are doing. I think the other thing that is, something that is very much a focus is the nature of our prison allows different types of offenders to be housed in different ways. So we are closely monitoring the trends of offending and the types of sentences being given, because the more types of sexual offending you see, that puts pressure on our vulnerable capacity. So we are very, very conscious that if we are going to see likely more of that type of offending being prosecuted, and it is appropriate for those people to be given a prison sentence, changing the nature of the accommodation in the prison becomes essential, because for the foreseeable future, it is likely, we think, that we're going to continue to see those trends. Against the longer sentences, there is the question as to whether we have people going to prison for very short sentences that should be dealt with in a different, still delivering justice, but in a different way. And the Chief Officer's alluded to the intensive work going on around tagging, and also, to build the confidence, I suppose, of the judiciary that there are appropriate options available.
I think the other thing is the other end of the prison spectrum. So when offenders get released, they have to have secure accommodation. And we have the bail hostel, which is actually far more successful than it's ever been, in that it provides a safe environment for offenders when they leave prison, and certain cases when people are on bail, but that's full. So if we're going to expand prison capacity, we also need to expand the capacity for the bail hostel. And so we're looking at a piece of work which looks at alternatives to custody. It looks at options to expand capacity in the prison, but also what happens when people go through the prison gates. Because if people leave the prison and they don't have settled accommodation, they don't have a family environment or some form of support, and they don't have a job, they're really going to struggle with not offending again. And often support for things like substance misuse, which speaks to what the Minister was saying about substance misuse courts.
The more you talk, the more worried I'm getting. Not because of what you're saying, but because of the scale and actually the quantum of work that is out there, and the fact that you are quite openly telling us that you don't really have the resources to do all the work that needs to be done. Do you feel that the government's current approach to things like the recruitment control framework is helping or hindering your ability to actually tackle some of these issues?
So I'm going to let the Chief Officer talk about some of the innovative approaches that we're taking to address our issues. But because we are very clear-sighted on the work that we know we need to do, and I'm very supportive of the approach that's been adopted by the Chief Officer of drawing in project management support, because some of it, what is challenging, I think, is for certain pieces of work you just need the frontline practitioners to be engaged, and we can't get away from that. So, and it will frequently be the same people, and I know we've both said this to this committee before, but it will frequently be the same people whose expertise and on-the-ground knowledge is part of the input to progressing and making change and having a different operational approach. But what is very, very difficult is to have the headspace and time then to pull all of the strands together, develop the operating policies and proceed, all of the detail that helps to drive change, whether it's a business case going forward. And so actually the route that we have been taking is to draw in on a task and finish basis external project support to push these areas of work forward. So, I mean, the Chief Officer can talk more about that.
Yeah, the recruitment control framework or anything like that is kind of a fact of life in the public service. In lots of ways, we recognise there are financial constraints, and I wouldn't want to be in Treasury shoes having to prioritise prison against healthcare, against essential infrastructure works in other areas. So we work with what we get. Last year, we looked at how we could outsource, as the Minister said, some of the heavy lifting. So we have got an external project resource that basically will help us do things like write operating procedures, write data protection impact assessments, and do some of the outputs, as well as just project managing stuff. They're there to do outputs. And so far, we've had a really positive response. So they've helped us with drafting all of the protocols and procedures for the different uses of tagging, for example. So we hope to bring forward tagging for court bail in the not so near future, which will then reduce the burden of people being sent to prison on remand because their risk level is high.
Can I just check that was in the not so near future?
In the near future. Actually, I meant to say not so distant future. In the near future. Thank you for correcting me. But they've done a really good job of taking stuff off the side of people's desk and actually delivering it rather than the operational work taking precedence. So that's how we've decided to use some resource we have in the department to provide extra arms and legs on the ground to do that kind of work. But as the Minister said, I think the challenge is they'll still need to speak to police officers about the operation of tagging when it's or electronic monitoring as it's introduced. They'll still need to speak to probation officers about what they believe the right threshold is to get that input. And at the same time, these probation officers and police officers are giving input into things like a MARAC for the Isle of Man, or they're giving input into how we address the prison population. So that there is a small number of people who are called upon because of their expertise and knowledge, and it's a real challenge. We're looking at the multi-agency safeguarding hub. We're looking at also, and I know you're going to talk about youth justice later on, but these same external people are developing a target operating model for youth justice, and they're speaking to all the same people. So we could have 20 people in the department who help to push these things forward, but if we don't have the subject matter experts, and if you've only got a small number of subject matter experts, then it's a pointless exercise. So we try and manage our call on their time really carefully, but I think we are moving stuff forward.
Okay, thanks. I think just going to talk briefly about the Justice Reform Act. So this was the department's last big legislative achievement in the last administration. It kind of came through towards the end of the last administration. I know you've spent a lot of time and work implementing that over the last few years, and there's been a lot of progress made. One of the requirements in that Act is that the Criminal Justice Board must prepare an annual report, and the first one of those, I believe, is due for the period ending 31st of March, and the law says as soon as possible after the year end. Obviously, we're only 7 days into the year. I don't expect the report to be ready. I'm just wondering if you have an indication of how you're interpreting as soon as possible. Are we talking about May, June time? Are you talking about December, January, late next year? What kind of timescale are you expecting this report?
I think in between those times is the latest
June,
thinking.
July, I think we're aspiring for that.
I think because of the governance process, though, because it is something that the Criminal Justice Board, so the Criminal Justice Board is getting reporting from the Community Safety Partnership as well, and one of the things that I think as part of this committee's recommendations is also due to be folded into that report is the work of the MASH, the Multi-Agency Safeguarding Hub. So I think all of that information has to go through the Criminal Justice Board and the department and so on. But I hope, yes, we will see it sometime in the summer, that first report.
Okay, and that's the reason I asked that is because obviously you're talking a lot about the rollout of the new criminal justice strategy and engagement. That report will be a report at a point in time of the current criminal justice strategy and the effectiveness. So I'd like to think that whatever comes out of that board will then hopefully inform the future development of the criminal justice strategy. It just seems like the timing is aligning on that, actually, for this report coming out from the board and the work that you're doing and the public consultation you've talked about.
And also the Chief Constable's annual report. That will go to Tynwald in...
We hope July.
I think the Chief Constable is absolutely committed to getting it to July.
Good.
We're hopeful that will go to July, and that will inform also with a lot of the information that he produces will help inform the criminal justice strategy as well.
Okay. As part of that report, or maybe separately, are you monitoring the effectiveness of12 of the Justice Reform Act that you've already implemented? So I know that not the whole Act's been brought in, and I'll ask you about that in a second, but one of the things that was brought in, for example, was 12-member juries for certain types of offences. That was in the Act, and that was implemented, I think, with the first appointed day order back in October 2022. I'm just curious as to whether you've seen any, what the effect of that has been really on, or do you not monitor that level of activity?
So we haven't actually monitored that level of activity. I do think one of the things that we also are looking to enhance and develop, and I do think this will speak to the criminal justice strategy as well, is still getting that overarching robust understanding of the justice system and its operation. So I think you took some evidence from the Attorney General about work that's going on in chambers around their case management system and so on. It's still quite frustrating that from a court's perspective and an Attorney General's perspective, it can be quite difficult to draw information rapidly to triangulate, what proportion of cases, for example, go to jury trial, what type of jury, how rapid, how quickly do things move from point of charge through to the end and a decision. So we're not, some of our ability to monitor is hampered, I would say, by the difficulty of drawing data in an efficient, effective way, rather than having to ask people to manually look things up and report to us. But what I really am keen to see is, as these digitising projects come on stream across all the constituent parts of the justice system, we do think, actually, what should we be monitoring, and then can we have that on a regular basis coming certainly from the justice perspective, and that's the criminal justice framework. Obviously, the additional bit, if I'm wearing my justice hat, is the overarching effectiveness of our justice system for civil and other matters.
Yeah, I mean, we've not got a lot of time here to go through everything. I think it'd be great at some point to do some evidence around the civil side of the justice system, because that often gets left out. I mean, even if you look at your legislative programme and all the work you're doing, it is predominantly, overwhelmingly focused on criminal justice, whereas actually all the other stuff that goes through the courts doesn't seem to get much of a look in. The reason I asked about the jurors element was it was quite a specific part of the bill, and it was one of the very few things that was enacted 2 years ago, quite early doors. And so I figured there must have been a reason the department chose to enact that part of the law then, as opposed to leaving it till later or not bringing it in at all as you've done with other parts. It's quite surprising to hear that you've implemented that, but you're not monitoring the outcome.
I think there are a number of ways in which we get feedback on the operation of the criminal justice system. One is within the Criminal Justice Board, and the General Registry, the Chief Registrar attends the Criminal Justice Board, as you'll see, and he is very good as part of that to bring feedback on the operation. So in some ways we haven't heard anything, so our view is no news is good news. But also the Minister, in her capacity as Minister for Justice and Home Affairs, meets quarterly with the judiciary and meets with the First Deemster and the Judge of Appeal. And through that forum, for example, the Judge of Appeal stated that with a number of cases coming up, it would be helpful to introduce the provisions around judge-only trials in certain circumstances. And so I think there are a range of ways in which feedback is sought and gathered, and the operation of the justice system is monitored. So that was quite a good example, and we've introduced that, and we were able to do that quite quickly by order.
So would you expect then, in terms of them providing an update to Tynwald, that some commentary on the implementation of the 2021 Act would come as part of the report from the Criminal Justice Board? I suppose is what I'm asking. I'm not necessarily looking for separate reports from every single department, every single piece of the puzzle, but actually some kind of holistic viewpoint that says actually the things that you have implemented are working well or are not working well and need to be changed. And again, the reason I'm asking that is because in your legislative programme you have another Justice Reform Amendment Bill which seems to be designed to fix problems with the original Act. But if you haven't had any of that formalised feedback, how are you aware that there are problems with the Act? I suppose it all ties in, it's the same question, really.
So, okay, well, we can help with this. I mean, the issue, if you remember, with the main thrust of the Justice Reform Act was to actually change where cases were going across the courts, so to try and increase the amount that the summary courts could deal with appropriately, to abolish committal proceedings, and to make sure that basically relevant cases were going to the right bit of the courts to be heard and dealt with. The reason we need the Justice Reform Amendment Bill is because actually when the practitioners, the courts themselves and so on, went to look at how the Act was going to operate, it wasn't going to quite work as intended. So that's the reason why chunks of it have not been switched on. So where we have been able to switch on something that's standalone, that wouldn't be affected by the areas that need to be changed, we were able to switch those on, and sections 4 and 5, which pertain to the Criminal Justice Board, are a good example of that. And the chief officers alluded to the fact we switched on the judge-only trials provision because we could do that without needing, it wasn't affected by any of the other areas that need changing. But the issue around the summary courts and how matters are allocated and how they move between courts, or between layers, I should say, of the courts, that's the area where there need to be changes to make that work as intended. That's the main area. But you're absolutely right. I mean, that's one of the reasons as well for the amendment bill going out for consultation, because we do have an opportunity, if there is anything else that needs tweaking, to tweak it at this point. But as the chief officer has said, we've had no particular feedback on the other parts that we've so far switched on to say that they're a problem. But we can absolutely ask the question.
I would say probably 15% of the Justice Reform Act has been turned on, and there's still a large amount outstanding, and that's mainly, as the Minister said, because when we got into the practical nuts and bolts of its application in a court setting, there was quite a lot of feedback that the way that the original Justice Reform Act was built wasn't really suitable, and there's a lot of work in the Justice Reform Amendment Act to fix some of those issues.
And why wasn't that captured as part of the original drafting and development process of the original bill? I mean, obviously the department would have talked to the Deemsters and the court system as part of the development of the bill in the first place, if you're now saying they've seen the exact same bill and said, oh, those bits are problematic for us, why wasn't that identified the first time round as part of the first set of drafting? It just feels a bit, I know a lot of work went into it in the last administration, but to have brought a bill through and then to say, actually, no, we've now talked to the Deemsters and it's problematic, well, surely that should have happened earlier.
I think there's two issues. One was it was drafted during COVID, and it was really hard. I think the application of the discussions around the detail of the bill with the courts were not as easy to have, and I think there's been a personnel change within the courts, and we've got a really good relationship with the legal officer in the courts and also the clerk to the magistrates now, who are far more helpful in terms of bringing the operational application of the bill. And so I think the close working relationship has really identified a number of issues which we probably couldn't get to before, and which, again, I think there's a lot of reflection. I think probably there was quite a lot of speed put behind the development of the Justice Reform Act, and more haste, less speed probably could have avoided a couple of these issues in the engagement and consultation.
So are there some parts of the Act then that actually may never be switched on? So I'm talking here about you mentioned the committal proceedings being, abolishing committal was one of the main reasons in the bill. That hasn't been turned on yet. Obviously we've seen quite high profile, at least one quite high profile case on the island be thrown out at committal stage before it actually went to trial. Has that caused a bit of a rethink now within the department, or is it you're still minded to pursue with that?
No, it's not that. It's just that the allocation, and so the way the Act was crafted actually doesn't speak well to the practicality of the way cases go into the system, are heard, and then are allocated. So it's, to that extent, amending the Act is a sort of technical job to make sure that the Act works with the outcome that was always envisaged, if you like. And the abolition of committal proceedings is still part of that, because it speeds up the process. Now, that's not to say, though, that where there is rightful challenge against whether proceedings should be continued, that will be lost. It will just happen in a different way. I think the other thing, to your point about, are there other areas where we're taking the opportunity to sort something out? Absolutely, yes. So one of them is, we still operate with quite a lot of wet signatures in the court system, which really isn't appropriate in the 21st century, and again is not helpful when you talk about speeding up justice. So we had different options. We've had that on the list to try and fix, and one option was to look at the electronic transactions work bill that's being progressed by the Department for Enterprise. But I think I'm right in saying we've held it as a matter to get into the Justice Reform Amendment Bill if we could progress that sooner. And I think one of the other operational issues that has been flagged to us by the courts are problems around jury re-entry. So instead of losing a whole set of selected jurors who are come forward for a trial, to be able to not waste that work. So we are going to pick up areas that have been notified to us as presenting a challenge in practice, and in a way having to do the amendment bill allows us to do a couple of these other things that are really worthwhile.
And just to clarify, even though the committal process will be abolished, there will still be an opportunity for a similar sort of process. So it's not to say that what happened in the case to which you're referring wouldn't ever be able to happen again. It would just happen in a slightly different way.
Would you think it's fair to say that the two officers, one being a drafter, one an officer, that drafted the Justice Reform Act probably had a very good understanding of the overarching vision for what that should and could look like, and did have quite close communications with the Deemsters around all of this in a very discreet way, obviously not sort of getting involved in policy, but whether or not things may or may not work. Do you think that the department has succession planned well in relation to replacing that knowledge base or not?
I definitely think we have. I think we've got 1.5 excellent legislative officers who have equivalent amounts of knowledge to the previous officer, and as I said before, we're looking to try and recruit another person to that role, so that helps us with our succession planning. So I'm really confident actually that the people we've got in place have a voluminous and encyclopedic knowledge of the criminal justice system.
I'd agree with you on that point. I think that what I'm trying to get at, I've probably not really hit the nail on the head with, and what I'm trying to get at is that this work was very, very far progressed, I think, at the back end of the last administration, and then the individual that was working on the drafting instructions, then working on various versions of the legislation, left. So how was that then dealt with? I suppose being that the policy officer was then dealing directly with the drafter, and that was then sort of sat in one bubble, as it were.
Well, so the person who's now our most senior legislation and policy officer was the number 2 to the person who was drafting. So I think that transition was handled fine.
Just seems a very long period of time. So perhaps, between, the saying that we're going to be bringing a piece of justice reform legislation that followed that act, it seems a very long period of time between then and
the amendment bill.
Now. Yes.
Yeah, I think the amendment bill has been a long time in coming. But I think that's just the department's had a number of competing priorities, and I think the Justice Reform Amendment Bill has been so complicated. It's incredibly complex because of all the different cross-references and the amendments to other bills. I think we've had other areas of priority which have taken away from a small team. I think also the drafters in Attorney General's chambers have had their attention diverted in other circumstances, and so it's just been one of those things that in a perfect world we would have had more resource allocated to it, but because in the department we've had limited resource to do some of the work we've done, and we've had to do it short notice, for example, it's just ended up bouncing backwards and forwards between the department and chambers for quite a long time. But we're quite hopeful that there should be a fairly final draft coming out soon, which can then go to consultation.
Thank you. So youth justice. Okay. So in February 2024, we had another meeting and we discussed the establishment of the Community Safety Partnership, possibility of operating in shadow form for at least 2 years before a formalised statutory body. Is there an updated time scale for the Community Safety Partnership to operate outside of its shadow form?
So I think we talked earlier, didn't we, about the Criminal Justice Board bringing forward its first report, and I think that part of what we also considered when we put the Criminal Justice Board onto a statutory footing is we recognised that further work would be needed around its governance and role, and I think it would be timely to also report on where we see the Community Safety Partnership going, because although it sits at the moment as a shadow subcommittee of the Criminal Justice Board, I think we recognised, and I think this is where the department, with its partners who sit on these fora, need to make an assessment. Community Safety Partnership work goes beyond the criminal justice system. So I think we always knew that by putting it underneath the Criminal Justice Board, that might not be the ultimately correct structure. I suppose the question is, we could again use resource to change the structure, but would we prioritise using resource for that rather than driving some of the actual work that needs to be done that makes a difference in terms of outcomes? So if we're satisfied and that the Community Safety Partnership has been operating as intended, we want it to keep going, and we do want it ultimately to become a statutory body as well. The question in my mind is always, are we losing anything at this point if we don't make that structural change in statute, but keep things going as long as we're reporting well and we're delivering, recognising that we will want to make that change at some point, if that makes sense.
I think the Minister's point is really valid. The Community Safety Partnership does appear to be working. I'm really pleased with how effective it seems to be in that the subgroups for substance misuse are really starting to work. There's a subgroup which is looking at the delivery of the Right Care, Right Person initiative, and there's, as the Minister said, we've got another group that's looking at things like domestic abuse, so things like Manx public protection arrangements and MARAC arrangements. So I think the group is actually working really effectively, and we'll obviously review the position at the end of 2 years, but there are benefits to it being on a statutory basis, but we will do an annual report this year from the Community Safety Partnership anyway, and that's obviously one of the benefits of it being statutory is it's required to present a report, but we will do that anyway. But I think as a body, it's really pleasingly effective at the moment.
And I think it would be fair to say that it has had good regular meetings with good attendance. One of the challenges, I guess, and again, this speaks to, putting things onto a statutory footing ultimately to really make sure they're embedded. But I think in its shadow form, it seems to have operated really well with good attendance, good reporting out, and as the Chief Officer has said, a number of working groups. I think one you didn't mention is on youth justice itself. So it has progressed is progressing a number of areas through its membership.
There appears to still be some level of consternation from magistrates regarding youth justice. Is that being fed through reasonably well? Are you taking account of all of those concerns?
Yes, so I think as the Chief Officer has alluded to, General Registry is represented in any event on the Criminal Justice Board as a conduit for all feedback from all parts of the courts system. But the Chief Officer and I have met the magistrates now. I think every sort of 6 months or so we've managed to sit down with them. So, and in particular, they are very focused on youth justice, having a range of disposals available and being very supportive of the work that goes on to try and deliver that.
And an example of that is conditional caution. So you'll know in the Statute Law Revision Bill there is an amendment to change a cross-referencing in conditional cautions, which will allow us then to start offering youth conditional cautions as a form of disposal. So once the Statute Law Revision Bill gets royal assent, we are preparing for that. I think you're right, the magistrates are frustrated at the lack of disposals, but part of the work we're doing on tagging will allow tags to be issued to be used for young people, and that's something that I know the magistrates are really keen on. We, as part of the work we're doing with the external consultancy Project Resource, they have interviewed the magistrates and asked them what it is that they would like to see, what the challenges they're seeing and what they would like to see. And our hope for the report that comes out, the target operating model for youth justice, is something that is practical, that can be used within the current resource. We recognise there isn't an unlimited pot of money for this stuff, but how do we use the resources we have as best as we can in the current system? So it will also then say, but if we had a bit more money or a bit more resource, this is what we could do as well. And we think that hopefully, there's certainly buy-in from every part of the Community Safety Partnership to use that report as the basis to move forward.
Still happy with the conversations that I'm sure will have taken place following the youth justice report from the Constitutional Legal Affairs and Justice Committee around Home Affairs and the Department of Health and Social Care, that sort of collaborative approach, but mainly led from DHA. Are you still happy with that sitting where it is at the moment, or is there sort of room for more conversation?
The Home Affairs does have joint policy working meetings with DHSE. I think one of the things, so for example, I think when we look back at the committee's report on youth justice, I think it was envisaged then that the multi-agency safeguarding hub might be able to replicate the work of the youth justice team. Now, the reporting on the multi-agency safeguarding hub is that it has been a success. It has definitely driven better collaboration between agencies, and it has flagged and created opportunity for early intervention and more support for those at risk of exploitation. And we've seen that feedback from the Chief Constable's report last year, but also from the safeguarding report. However, so it's a really positive thing. However, it probably isn't the right vehicle to do all the work that you would look to do in the youth justice space, which is why we recognise that, since your report came out, we knew that the Children's Services Improvement Board came forward, which was very much working strongly with DHSE, although Home Affairs did have a seat at that board, so we were linked in. And I think there was work that was envisaged by children and families in Manx Care around how they could develop out their youth justice work. So my view would be, these are all great initiatives and we've got lots of work that's going on, but the report that the Chief Officer's just alluded to that we're getting from our project resource is to actually say, okay, what's our as-is offering? Is it working as well as it can in terms of delivering responses to youth justice now? And if it's not, what are we going to do to fix that? But actually, critically, what is our target operating model that we should be working towards? And I think in that space, we do have to have a discussion about how do we make sure that all resources are aligned. And one of the things I'm quite interested in, obviously the Children and Young Persons Act is going to be considered for updating an amendment. There's a question in my mind about, could we be more aligned in our legislative framework around youth justice? Because would that help support the relevant agencies also being effective and aligned? And I don't have the answer to that question, but I think it's a good question to ask.
I'd agree, it is a good question to ask. So as we're talking about those sort of cross-departmental working, particularly between DHSC and DHA, I'll leave it to...
Yeah, I just had some questions about the that you mentioned, the right care, right person model initiative. How do you want to describe it? Obviously, you'll be aware the Manx Care mandate this year posits quite a significant change in what Manx Care are mandated to do in respect of that. In the previous year's mandate, there was a whole page actually mandating certain levels of cooperation with the initiative as a whole. That's all been removed from the mandate now, and also there's been a specific removal of any requirement on a particular part of that, the ESJCR model. I'm just really from your perspective, does the department have any concerns that this previously mandated level of cooperation has been removed now from the Manx Care mandate? Is there any indications that's going to present any operational issues?
So it is an operational matter between the Chief Constable and Manx Care, in that the Chief Constable is really keen to ensure that where people have a mental health issue, they're treated by mental health professionals, not by police, or dealt with. I think that's really important, and the Chief Constable has been really clear in those views, and he's shared that with Manx Care leadership, and they have taken that on. I think we have a role in reviewing the mandate to ensure that where there are services, so for example prison health care, are provided, that we understand what that is. There has been a change in the way that the mental health support has been updated in the mandate, but ultimately I think it is for the Chief Constable to ensure that the services he's receiving, or the services he expects to receive from Manx Care, are in place in the way that he expects them to be. So I think the department's policy is that we support the Chief Constable in wanting to ensure that where people are in mental health crisis, they receive a mental health worker and not a police officer, except where there is evidence that they may well be able to harm themselves, be able to, or other people. But ultimately, how Manx Care delivers that is a matter for Manx Care and DHSC.
But from your perspective, your seat on the Community Safety Partnership, where all this is kind of overseen from, as far as you're aware, that partnership hasn't raised any particular concerns and no information has fed through that to the department?
No. So that partnership is really effective and is working to transition to the new model of working. I don't think they've raised any particular concerns So I certainly, but nothing raised with me.
No, and I think, in fact, the group that's sitting under the Community Safety Partnership working through this, it is very operational, because actually it's translating, it's going through, there are a number of operational procedures anyway and standard operating procedures, so they're actually working their way through that. I think anecdotally, the one thing that has changed is the pilot, in terms of somebody on call from the mental health team, was initially in the control room, and I think the feedback, certainly that we got in Home Affairs, was that wasn't the best use of the relevant mental health worker to be actually in the control room. So they switched the pilot for the second half of the period to having them in Manannan Court. Now, the anecdotal feedback is that has worked well from a policing side. So they have been able to get through to someone, and it has facilitated a response of the right type. I think we would like to see the actual reporting out of the pilot, but I think that responsiveness was one part of the entire operating procedure around right care, right person. There are a whole raft of other elements to the right care, right person operating model, and as I say, that's the piece that they're working through their standard operating procedures.
So you haven't seen the analysis report that was undertaken?
So that was, the pilot's only just finished there.
No, sorry, there was an analysis report undertaken after the first 6 months in September 2024.
So we haven't had a response from the Chief Constable on that.
Right. But the ESJCR, they work for the Department of Home Affairs, they're not part of the constabulary. Is that correct?
That is correct, but
so I have a written answer from the Minister for Health and Social Care, which states a multi-agency operational group that consists of representation from the Constabulary, the ESJCR and Manx Care all unanimously agreed that the model of delivery was inefficient. But you're saying actually you're not aware of that report that was undertaken?
Again, because it's an operational matter in the way that I think it must be referring to the Community Safety Partnership Group, that group has had oversight of the operational delivery of that person, and whilst there is a person there from the control room, they were really only seated in the control room. They weren't part of the ESJCR team as such. So for example, we host the clinical navigators in there, but they're Manx Care employees, and we really give them a table and access to welfare facilities in the control room. So where there's an operational group meeting to discuss the efficacy of a pilot, we wouldn't necessarily see that report.
And I think, just to be very clear, I think the feedback was saying that there were only, because I think I'm right in saying that the mental health worker was present in the control room for about 8 hours a day, and they were averaging, I can't remember the detail now, but they were averaging a couple of calls that were necessary. Yeah. And the view was that was not best use of that resource to be sitting there for that length of time on the averaging the calls that they were dealing with. They would be better placed in Manannan Court, where they could do other work and still respond. So that was the thinking. But the other change with moving to Manannan Court was the 24/7 access. So instead of having 8 hours a day, it could increase the time period. What we haven't seen is, what are the volume of calls that have been going through to that person since they've been based in Manannan Court. But the anecdotal feedback is it's working.
I'm just trying to understand the governance really around this, because the information that we've got talks about the Community Safety Partnership providing oversight of these sort of cross-government pieces of work, but it would seem the CSP hasn't seen any report on this, and the information that's coming through is quite mixed in the one respect. I have a written answer from the Health Minister saying that it was a unilateral decision at one point, but also it was a unanimous decision. I have a letter from the Chief Constable saying it was a mental health service report concluding that they couldn't justify the resource. It doesn't feel like someone has actually taken a step back and looked at the effectiveness of this against the system as a whole. It more feels like Manx Care have said, actually this isn't working for us. That doesn't feel like a joint approach to me, and it's a little bit concerning that the CSP doesn't appear to have had any oversight of it, and actually then the department doesn't appear to have had any involvement other than, like you say, the anecdotal feedback that you're getting.
The department will look to the CSP to report from that right care, right person on, as I've said, that they're progressing with all the standard operating procedure implementation, and all of that is agreed and underway, and also to get the full year pilot feedback. It only ended in, I think, just at the end of March. I don't have the date off the top of my head, but it is literally only ended. Because you're right, we would say, can we see the full picture? That you've run this for a year, up until September, somebody was in the control room. The sort of hot feedback, if you like, from that point was, it's not the best use of resource from a mental health professional. Can we try it with them based in Manannan Court? The anecdotal, as I say, feedback at this point, certainly from the constabulary, has been it has worked in Manannan Court. But I would agree with you, we should, through the Right Care, Right Person working group and the Community Safety Partnership, see and it's underpinned by volume of calls, responsiveness and so on, so that we are clear how this should work best going forward.
I think my underlying concern here is, and you mentioned it before, that you may not need to put the CSP on a statutory basis if actually everything's working fine. Everything was working fine with the old youth justice team until it wasn't. And because that never had any kind of firm statutory backing, all the various partners could walk away when it suited. And it feels like the same risk applies here, that actually everything is fine as long as things are working and there's enough money for things. The moment budgets start getting tight and people start having disagreements, there is a real risk that actually this collaborative working falls apart.
I mean, I think it's a fair point all the time as to what should we say has to have a statutory basis, and it's that line between operational effectiveness and joint working, and where should that best sit and be overseen. So, I mean, I wasn't suggesting earlier that we shouldn't put the community safety partnership on a statutory footing. I was almost saying, when do you prioritise doing something like that versus the other work that all those people are involved in doing? So please don't think I was suggesting we pull back from doing that. But I think, as with everything, where is there a case for making sure a structure will be embedded and continue to deliver once we are clear that operationally that's the appropriate thing to do?
Right, okay, moving on.
A couple of questions on the Sex Offences and Obscene Publications Act 2021. And specifically, do you think any additional training or resources are required to carry out this new legislation?
I think we did a huge amount of training before it was introduced, and the effectiveness of the constabulary in particular in investigating these crimes is really impressive, actually, considering it only came into force in March 24. I think extra resources are probably needed in the constabulary, particularly around investigations. That team are really, really stretched, but also in terms of managing sex offenders on an ongoing basis. There are increasing numbers of sex offenders with sexual harm prevention orders, and they are in the community and they need to be monitored, and it's quite invasive monitoring, looking through people's hard drives, for example, checking their whereabouts, looking at phones. So I think the resource is probably at the sharp end of the constabulary in terms of that. I think from a training perspective, there's been a huge amount of training. The Attorney General's prosecution has been really, really helpful in rolling this out. And in fact, I think one of their newer recruits has a background in prosecuting sexual offences in the United Kingdom. So I think I'm really satisfied with where it's got to. And as I said right at the start, the impact on the community, particularly for victims and survivors of sexual offence, has been huge, in that people feel like they've got a voice, and there are a whole range of new offences now which have been identified, and I think the ability of the police to prosecute a far broader range of offences has made a huge difference.
I think I would probably add, I alluded earlier on to the fact that the department is looking to do a stock take as opposed to full post-legislative scrutiny about 18 months in. I think that's a good opportunity to say, what are our needs? We also do have a Sexual Offences and Obscene Publications Act working group that was put together anyway around some of the further secondary legislation and so on that we still need to bring forward. So that will meet to do that, but it's another good forum to say, are there any further needs, whether it's training or otherwise, that we identify.
I mean, in terms of children, it's a scary time to be a parent, I think, these days, because, you know, all these online things that kids have got access to instantly, which when I was a kid, we never had any of that stuff, of course, because everything was in black and white. What education's taking place in schools, then, to promote the Sex Offences and Obscene Publications Act?
I think the Department of Education do a lot of work in their PSHE around awareness of things like grooming, of safe use of devices, but I think parents also have a role to play, don't they? It's not just for the department or for the government to take a role. I think parents have to understand that they give their child a device, but they should understand the implications of giving a child that device and ensure that they have an open relationship with their child so they can have discussions and explore the risks to using that device and the exposure to other people, and particularly where you have things like grooming going on, which can be hugely invidious and very sophisticated in the way it's done, and often children are groomed before they even realise it. So I think, you know, I know the Department of Education have updated their PSHE curriculum quite recently to include advice and support to young people on how they use their devices and to understand what else is out there and the risks that they face. But I think parents, it's incumbent on a parent, if they give their child a device, to ensure that they equip them with the knowledge and skills and understanding to use that device safely.
I think just, you know, the police, it's your question is timely, because I imagine if you haven't seen it, you've certainly heard of it, the adolescence series that was on. And in fact, I saw a report only last week, I think, that the police have actually been engaging in our secondary schools, because suddenly, obviously, a programme like that or a series like that is a conversation point, but it allows suddenly for a lot of sharing. So, for example, they've been in sharing what emojis there are, and actually, as the chief officer said, often this is more to educate the adults in a child's life, whether they're parents, carers, teachers, or otherwise, to make sure that we have a better understanding of what children may be seeing, and then can try and support and intervene appropriately. But the police have been active in doing that, so I commend them for that. And I think one of the things that I've noticed with all the service areas of the department is, if they can go in and offer education, whether that's in schools or in other settings, if I think about the fire and rescue service will get involved in trying to support vulnerable people, then when their resource permits, they will be proactive in doing that work.
Okay. Let's talk briefly about border strategy. DHA published the Securing Our Island strategy in September last year. One of the aims was improved use of technology to keep the island's borders safe and to verify identities. Part of this was the deployment of ANPR and facial recognition technologies at our ports to detect criminals and terrorists. You mentioned that the legislation to enable ANPR for policy use is now complete, to be laid before Tynwald before the end of, 2024 actually, and that you'll bring a bill to the House of Keys by the end of January 2025. I'm not quite sure about that, to enable the use of facial recognition. Where are we with all that?
So yes, we have progressed a number of actions under that strategy. You may be aware that a new dogs team was introduced at the ports last summer. The completion of the integration of ports policing with the constabulary went live on the 1st of February, so that is operational now. And in any event, there's been closer working between the police and customs and immigration jointly at the ports. In terms of our legislation, we talked earlier about the work that's gone on to introduce automatic number plate recognition at the ports. So on the April Tynwald order paper is the package of legislation that will facilitate that. We have an appointed day order we had to switch on to use a relevant provision in the Police Powers and Procedures Act to bring the relevant code forward, but we have the order and the regulations, and if those are supported by Tynwald, then effectively the other work that has also gone on in the background that the Chief Officer touched on, which is data impact assessments, all sorts of training and awareness, then all of that being in place, we will be able to link our cameras that are already there at the ports to the database in the UK and use it for the purposes of detecting and disrupting serious and organised crime. The piece on facial recognition, I think we touched on earlier as well, which is the regulation of surveillance bill, which is progressing as a draft. That we're still hoping to bring into the branches, I think, this before the summer.
Yep.
So that bill will have provisions in it which would enable the use of facial recognition. Obviously, that's on a longer timescale, though, because primary legislation, as we know, has to go through the branches, get royal assent, and, of course, then there's implementation work around that. And I think we also touched on before the Information Sharing Security Bill, which is designed to facilitate more regular use of and information sharing between law enforcement agencies, and we are working with the Treasury and Treasury officers to get some support to try and progress that.
The facial recognition question is quite interesting because at the moment, of course, at the ports you're not required to have ID to get on the boat. Do you not think that perhaps an ID requirement would be slightly less invasive than facial recognition?
From an operational perspective, if I can answer that, the use of facial recognition is in some ways less invasive in that it will immediately dispose of any images that aren't a match with a criminal image. So whilst it will look at every person passing through, the images are immediately discarded, and it's only when you have a match to a known criminal that that person is identified. So we think that it's about layers of security. One is identifying criminals coming through to the island who aren't known to us. There's also something around the use of intelligence to identify when there are criminal movements. And there is another layer which the constabulary are keen, and the department is keen to support the constabulary in using information that is gathered on exactly who is travelling. And the department's view is that if you travel by plane, in certain circumstances, you are required to provide information on who you are. It's very difficult, for example, to buy a ticket for cash to fly on a plane direct from the travel agent, and you have to provide the details of your name and address. If you're travelling to Europe, then you have to provide all of your details for onward transmission for the purposes of preventing and detecting crime and terrorism. So we think that putting it on a reasonably, on a similar basis would be proportionate.
I think it's a really good question that any changes around this are about the effectiveness of detecting and disrupting crime. But I agree it's about proportionality too. And I'm glad you asked the question because, as the Chief Officer has said, none of this is held or captured. And the same is true actually for ANPR. I mean, what that is basically doing is it's rapidly scanning number plates against a watch list, for want of a better expression. So nobody's interested in your number plate if you don't match a known vehicle that, and the constabulary will have a number of markers which are indicators of that vehicle being used in connection with serious and organised crime, and that's the purpose. But I also think, as well as the legislative basis, what is so important with all of this is the underpinning framework around operating procedures, training, information commissioner sign-off, because I think that's what gives people the confidence that this is proportionate and not designed to be invasive, but designed to do the thing that we are looking to do, which is basically detect and disrupt the serious criminals.
I think we could all ask questions all day on this and listen to your answers. It's been a very, very interesting evidence session, but I think I will come to a last question from either one of my colleagues here. And in that case, because we are so short on time, thank you very much for your time coming in today. Justice and Home Affairs, Minister the Honourable Jane Paul Wilson, MHK, and also Dan Davies, Chief Officer of DHA.
Thank you.
Thank you.
Thanks.